Can you sue for your pet's pain and suffering? Well, one woman sure is trying. We're joined by WGY legal analyst Paul Harding of Martin, Harding and Mazzotti. Good morning, Paul.
Good morning, Kelly. Chuck, how are you?
Hey, Paul, great. How are you?
Very good.
Okay, so here's the background here. This woman bought a dog from a pet store, and the dog was later diagnosed, I guess, by a vet with some hip problems and other health issues. The woman is then suing for the price that she paid for the dog, which was $1,600, plus $8,000 in vet bills. And then she's seeking an unspecified amount in pain and suffering for her dog. Can she do that?
Well, no one's been able to do that yet. There's no precedent allowing pain and suffering, and she is in the New York City Court, which has a maximum recovery of $25,000. So this thing has gone on. People have tried it in the past. It has always been thrown out, and this judge has let it go forward. So it certainly has made some news.
So it has been tried before, and on what basis was it thrown out in the past?
That there's no standing. There's no cause of action. You can't step into the shoes of what your dog may have felt or may not have felt. So, in essence, a dog cannot bring a claim for pain and suffering. It's a very personal cause of action. An individual has to bring it. And so it was always thrown out. The judges let this proceed. Possibly, again, we're in a lower court. It may have been something that he or she just didn't want to complicate and allow the case to move forward. But when it comes time to resolve it, they will get rid of that cause of action. Also, I don't know. It certainly is... I've had conversations with people. They've called my office, and they've made strong arguments that what their dog has gone through. But I just don't see them making that leap to pain and suffering.
Well, I think what's confusing here is that they're suing the pet store for selling a defective product. Now, when you use the term product, it kind of infers that it's an item or a possession, and therefore couldn't be capable of enduring pain and suffering.
Yeah, in New York State, your animal's deemed property, chattel, as if there was damage to your car. So you get the value of the damage to that property. And as far as the defective aspect of the dog, there is a puppy lemon law.
Right.
And you have a certain amount of time after you get a dog to have it checked out by a vet. And if they find problems, you get reimbursed. But beyond that, New York State has not allowed any compensation for anything beyond that.
So let's say you brought your puppy in for a simple operation and your vet totally botched it and the dog was either, harmed or killed as a result. Can you sue in that circumstance?
Well, you'd have to prove that there was a botched operation, which, and even in a medical malpractice case, if an individual has a procedure and things go bad, not all procedures that go out bad result in malpractice. So I think you'd have to prove the underlying issue first, and you're probably getting into some serious expenses.
Now, if you want to claim pain and suffering in relation to a case about a dog, could someone claim that watching their pet go through these health problems and endure the pain and suffering, being so close to their pet, that they suffered some pain and suffering as a result of watching the pet go through this?
That's a great question, and it has been tried. That has been tried because if we all have pets, and you get very attached to them, and there is that component to it. But New York State has absolutely a law that does not allow there to be any recovery for pain and suffering as it pertains to your animal. Watching any emotional distress, any event that's going to cause an effect on you, you do not have a cause of action for that.
Okay, WGY legal analyst Paul Harding of Martin, Harding and Mazzotti, 1-800-LAW-1010. Thanks, Paul.
Okay.